So, Asha, are Republicans going to be able to muck up the Manhattan prosecution of Donald Trump?
It's complicated. I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal and national security analyst.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down to a soundbite or a tweet. It's another late night.
Yes, indeed. You've got a glass of wine. I am blitzed because I went out with a client, so I've already had a few drinks. So I'm way ahead of you.
Oh, okay.
So this should be a fantastic episode. And full disclosure, we're re-recording this for a bunch of reasons, but one of which is we got some new news, right? I mean, we have a new lawsuit filed by Manhattan DA Alvin Bragg. I got to give the guy credit. He's a very aggressive individual, right?
He is aggressive. He's
not
afraid.
Sitting around.
He is not afraid. Yes. So basically, my internet went out while we were recording this morning, and then by the time it came back, which it's so weird, it was out for all day. We got this new news, and basically, it looks like Bragg has filed a lawsuit in federal district court in Manhattan. I guess challenging Jim Jordan's authority to conduct oversight over his investigation and prosecution of Trump, and then also asking the court to invalidate a subpoena that Jordan has issued to Mark Pomerantz.
It's an interesting word you used, Asha, oversight, right? Because we usually think of oversight in the context of Congress overseeing the actions of, let's say, the executive branch.
Right.
And they appropriate money and they want to make sure that, the executive branch isn't doing something improper, illegal, whatever with the money. Here, he wants to oversee what a totally separate sovereign entity is doing, right? A totally different level of government. It's an unusual exercise of congressional authority, to put it mildly.
Yeah. So this implicates federalism concerns, right? That, this is the party of limited government and states' rights. So I'm not really sure what's exactly happening here. But you're absolutely right. The oversight function of Congress, which isn't explicitly laid out in the Constitution, but is implied as essentially a separation of powers check, right? This is their ability to gather information that can also inform their own job. In other words, if they don't have the oversight ability, then they are unable to create the laws that they might need to create to, fulfill other parts of their Article 1 functions. It's hard to see where that applies here, though. I think Jordan's hook is he wants to know what federal funds Alvin Bragg might be using in this prosecution.
Yeah, it's very bizarre, right? Because on its face, it's not clear that there's any federal funds being used by the Manhattan DA. It's a local prosecutorial entity. And putting that to the side, Jim Jordan and his, I think, aptly named Weaponization Committee, although not for the reasons they think, they've been, making all of these arguments about how Bragg isn't doing enough to fight violent crime in New York, and they're trashing New York. It's kind of weird, right? He's a guy from Ohio. He represents Ohio. I'm really not sure what any of his thoughts in New York are relevant to anything, right?
Well, bizarre. Yeah, I was reading that they plan to do some kind of field investigation where they're gonna, they would be holding. I'm reading from the Washington Post. Republicans on the House Judiciary Committee announced that they would be holding a field hearing in Manhattan next week to examine how Bragg's, quote, pro-crime, anti-victim policies have led to an increase in violent crime and a dangerous community for New York City residents. how is that their concern?
It's bizarre. They're spending our taxpayer dollars to all travel to New York to do this. It reminds me of during the Trump administration when they, Bill Barr came to Chicago to come preach at us about how awful our city was and how, we're the scourge of whatever, we're the scourge of America and why Trump needed to get reelected. It's just a bizarre political sign. And let's face it, I don't think Jim Jordan cares a lot about the people of New York. If he does, he has a weird way of showing it. I mean, dissing their city and talking down to them is not a good way of showing actual concern for people in New York. I think, it's just what's interesting to me is just how transparently they're an arm of Trump. I mean, it's an interesting thing, right? I mean, most defendants, when they get indicted, are effectively powerless against the state. I mean, very little. Yes, you have these ability to challenge things in courts, but you're basically the power disparity is so great. The government puts out this press release, and that just overwhelms anything you could say on the defense side about it, and it ruins the person's life. They often lose their job or their business is ruined. And they don't have the ability to fight back in any conventional way. But here, Trump is exchanging information, right? There was these reports, Asha, about, I think, exchanging information with this weaponization committee and so on. So essentially, Jordan is using our tax dollars to further the Trump legal strategy.
Right. They're an extension of his legal defense team. And Fox News is his personal PR arm. I mean, we know that from the Dominion lawsuit that they're there to promote pro-Trump narratives because that's what their audience wants to hear, and they're going to lose their audience if they don't. So he's got this whole, propaganda arm, and that's what I actually think this weaponization committee is large. I mean, because there's so little there legally, such on a thin legal basis that is really there to create. It's to be performative, right? And to the question that you asked opening this episode, to kind of muck it up and create a lot of noise around this investigation so that public perception is then altered.
Yeah, so Trump, he has really, he's using our own tax dollars, essentially public resources, in part for his legal strategy. He really has something that is less than perhaps he had when he was president, but still very substantial, very different than the typical defendant. And I think what he's really trying to do is actually do whatever he can to push the judge's buttons and try to push the envelope to create a situation where the judge feels compelled to issue a gag order or take some other action against him. I think Trump is looking for a way to recuse the judge or try to, at least make a motion to suggest that the judge is unfair. And, regarding a gag order, the judge, I think, is very wisely in this case, not taken the bait, not issued such an order. It hasn't even threatened it. And that's, look, the free speech, First Amendment concerns regarding a defendant are always, something that is given a lot of weight by judges. But particularly here where Trump is running for president, I think the judges wisely steered clear of that. But I think Trump has correctly calculated that allows him to get away with a lot of what you were just mentioning, Asha, which is sort of creating disinformation and trying to shape public perception of that prosecution.
Yeah, for him, it's a win-win either way, right? Either the judge doesn't take the bait, as you said, and then he gets a very, very long rope, to make really crazy statements about the judge, about the prosecutor, about their families, things that I think no other defendant would get away with being able to say. Or he's treated like any other defendant and maybe a gag order is placed on him, but then Trump gets to claim that obviously they're trying to disadvantage him as a candidate, and they don't want him to talk, and that this is impacting his First Amendment, not just first free speech, but also his political activity, right? Because it's intersecting here because he is a political candidate. Either way, he gets to shape this narrative, and then, as you mentioned before, he's got Jim Jordan on board basically laundering this idea that this is politically motivated through a government function. Like using a very serious and powerful mechanism that Congress has as a way of legitimizing this narrative so that when it all appears on Fox, it looks legit.
Yeah, and I think it's important that you made that point, Asha, because I think that's what Trump gets out of this. In other words, a lot of people were asking me today on Twitter, oh my goodness, is this, is Bragg going to win his lawsuit? Is Jordan going to succeed? And really, from Jordan's perspective, it doesn't matter. I mean, this is all about creating sound bites on Fox News. And so if he's stopped in the courts, even better, right? He can blame the liberal judges or whatever he wants to claim. The reality of the situation is that, congressional subpoenas are challenging to enforce. And the Democrats had to learn that the hard way over multiple years during the Trump administration. As a practical matter, it's going to take some time for this to wind its way through the courts and whatever, right? And he has a chance, Jordan has a chance, because courts are so deferential to the legislative purpose that Congress says it has. But it's by no means a slam dunk. But nonetheless, even if he fails or even if it takes too long, he's going to succeed if he gets himself a few more hits on Fox News.
Yeah. By the way, this is for a future episode, but they're already starting some noise around the Mar-a-Lago investigation also. Did you see some of that?
Yeah. I noticed that something's happening behind the scenes, Asha. There's too many truths or whatever they're called going out right now. And you saw that, was that trusty guy? Jim Not So Trusty on Meet the Press this weekend?
No, I didn't.
Okay. You're probably on another network at the time or something. But yeah, they had one of Trump's attorneys on Meet the Press talking about the documents case. So clearly there's something brewing there behind the scenes. They know things we don't, but we'll see. I mean, we'll have to wait and see. Certainly from our outside perspective, it looks like the most serious jeopardy for Trump, and I think the case that is the strongest. So we'll have to wait and see. But as I've said before, I wrote a column about it. Fighting a war on multiple fronts is hard, and I think it's going to be hard on the PR front for him too. I mean, it's just hard. It's always hard to explain away all these different things. Like when the kitchen sink is coming at you, it could just be challenging. Trump's managed to do it, but it'll be interesting when he's facing all these court cases, whether he can keep it up.
I have to say, if he's right, that we have an incredibly coordinated state and federal system of government that can put together these very complicated conspiracies on so many different topics and frame him for everything. I mean, that was not the government that I need. Government is typically bureaucratic and slow moving, and I don't even think you could get a bunch of people, civil servants, to agree on anything in a room. But I guess they're just super sly co-conspirators.
Yeah. We always, so prosecutors, at least in my district, we have this fancy jury argument we always use where it's like the unluckiest man in the world. And it's like, so Donald Trump would have you believe he's the unluckiest man in the world, the Manhattan district attorney, the Fulton County district attorney, they're all conspiring against him. You would weave all the facts. You've got to walk through all the facts together, right? The Mar-a-Lago documents planted in his office. Of course, the grand jury subpoena, he must have lost it. That sort of thing. And you'd have this sort of mocking tone. You'd go through all the evidence and show that just what a coincidence.
Yeah. But it gets to, the fact that there are two courts that are in play. One is the court of public opinion. One is the court of law. And, we believe that it's just what happens in the court of law that matters. And that's true. But the legitimacy of our system of justice and the rule of law is also dependent on people believing and perceiving that it's just and that it's fair. And so his ability to manipulate perception is really important. I mean, we have to pay attention to that, and we can't just dismiss it just because now it's in the legal system. Because, when we don't want that faith to be eroded. And I say this also when people are poo-pooing, Jack Smith, and they're just like, oh, nothing's going to happen. And there's this apathy that comes in. I don't like that either way, because you have to believe in it for it to work.
Yeah, I agree with that. I mean, look, Trump has done more than almost anybody in terms of eroding faith in law enforcement and our judicial system. I think that a healthy skepticism about the exercise of government power is always a good thing. So I don't think people should just accept every time a prosecutor says something or any other organ of government says something. But he has sort of, without any evidence, without any reason, had so many, blistering and unfair attacks against every level, really, of our, law enforcement, judicial system. I think it's something that we're not going to recover from for some time. And I one of my, concerns, I think, going forward is how our politicians are going to be policed if we do not have a prosecutorial system that the public has faith in. In my home state, we have lots of corrupt politicians. We're in the midst of wrapping up a big public corruption trial here in Chicago now in federal court. We rely on federal prosecutors to police our system. If we didn't, this state would be in much worse shape than it is. And I just think a lot is lost if we lose faith in, prosecutors, law enforcement, the judicial system to police corruption.
I agree. But don't forget, Renato, Trump is the unluckiest man in the world. It's different in his case.
Yes, he is. So, Asha, we have to talk about the Manhattan DA case, right? I mean, I feel like
it's our albatross now.
It is. Well, we were half asleep the last time we talked about it. Let's be fair. I gave a BBC interview right afterwards. I listened to it. I sounded like I was comatose when I listened to it back.
Did you ever get those op-eds written? You had like 2 op-eds to write.
I can't. So I wrote one and I canned the other. It's interesting. So the one that I wrote, it was about what I viewed as a lack of clarity in the indictment of Trump, and I am very concerned about that. And it's because essentially in the state of New York, the crime that Trump was charged with, falsifying business records, is usually a misdemeanor, but it becomes a felony if it is committed with the intent to commit another crime. So if you falsify business records with the intent to commit a tax crime or an election law crime or whatever, then that is a felony. And I think we both were expecting that the indictment would lay out what other crimes Bragg thought Trump intended to commit, and it did not do so. And essentially, my column was very critical of that, because I just think we all, in this sort of very high profile, very important prosecution in American history, we deserve to know that. And I think the defense deserves to know that. But there was certainly some strong disagreement from one individual I talked to who's very familiar with the investigation. And I've had a lot of discussion and debate with former Manhattan assistant DAs and defense attorneys in that jurisdiction ever since.
Yeah. So, and I think that this was really the approach that almost all the lawyer commentators that I was following. It was like, well, which crime is going to be the bump up? That was it. And we were like waiting for it to be specified in each of these counts or somewhere. And it wasn't. And you wrote that piece and I was completely on board. And then we learned that in New York, you not only do not have to bump this up to a felony, you don't have to specify the crime that the person intended to commit by falsifying the records in the indictment. And to me, this was even more shocking. You don't even have to specify it to the jury. Like, you don't have to, so a jury could, half the jury could think that he intended to commit one crime and half the jury could think he intended to commit some other crime. And as long as they believe that he intended to commit a crime.
So yeah, if this sounds a little crazy to you, it was a head scratcher to me. What Asha's recounting is essentially what an individual very familiar with the investigation recounted to us, essentially relying on a burglary case. There's a statute in New York that makes it a misdemeanor to trespass into the home of another, but it becomes a felony if you do so with the intent to further another crime. So, for example, if somebody had brought condoms with them, perhaps to prevent DNA evidence from being left after, committing a sexual assault, or, if somebody brought a gun or duct tape to try to tie someone's hands, or, whatever, hand ties, that would be evidence that they were entering the home with the intent to commit a further crime, not just the trespass, versus, let's say, bringing a sleeping bag because they just needed a place to stay.
And to clarify that, in such a case, what that burglary case says is prosecutors don't have to specify to a jury, or even in the indictment or to a jury, he intended to commit rape or he intended to commit assault. That circumstantial evidence would be enough that he was just going to commit another crime. And we could talk a little bit about the differences between that case, because I could see a jury reasonably coming to that conclusion if someone trespassed into a residence and had a knife and rope and a gun and condoms. I'd say that sounds pretty crimey to me.
It does. It sounds like another crimey, right? For intent to commit another crimey. But I will just say this. I mean, one thing that the listeners should understand, that is not typically how things work in America. The way it usually works in most jurisdictions is the purpose of an indictment is to lock in a prosecutor, and they have to specify what you're charged with. And defendants actually have a constitutional right to fair notice now of the charges. The argument here is that this isn't the charge. This is some other sort of enhancement. One thing that I will say that a couple of things about this. I mean, this is the position that the Manhattan DA's office is taking, or has, at least that's my understanding of where they're at in terms of what their position is. But I don't know if a court in New York would see this statute the same way, because in this particular case, the other crimes appear to be, we can't be sure, but they're alluded to be by Bragg in a public statement and in the statement of facts to be election law crimes that are totally unspecified. And I think it's fair to say they're not your typical election law crimes, because typical election law crimes don't involve like paying off porn stars as a quote campaign expense. I think that certainly some explanation is necessary there. And then tax crimes that are unspecified. And I think it's pretty well established in our law that tax laws are very arcane. And that's why actually, many jurisdictions, you have a heightened requirement for the defendant's state of mind, because there's a presumption that the average person doesn't know enough about tax law and is relying on help from others. So I just think the idea that you're going to have a jury sort of figure out themselves, like just sort of like give them a big shrug and like you figure out amongst yourselves what the election crime or tax crime here could be, I think that's very problematic. And I just have trouble believing that, first of all, that the judge would let this go to the jury in that fashion, because there's other ways you could do it. You could have a special verdict form. You could, certainly I think the judge could require in a bill of particulars, which is what I suggested in my column in Politico, would be, I think, a good avenue for the judge to require more specificity. So I think that's what should happen here. I think that's what I would think a court would require. But regardless, I just think in this particular prosecution, I really think it would have been in everyone's best interest to just spell it out.
Yeah. And I mean, just to use the burglary analogy, it's hard because you don't have the equivalent of the knife and the rope and the condoms, right? You have this elaborate structure of repayment, which is based on, sham invoices or whatever. I suppose, I started to go down the road of like, well, what would be an innocent reason that you would structure a repayment this way? where you'd have fake invoices for services that were never rendered, that artificially inflated the recipient's income in order to net the right amount after taxes. I mean, I suppose that could go to something, because I don't know that you would have I don't know that there are many innocent explanations, but as you said, there's no obvious crime. Like, what is the crime? I mean, is the jury just left to, as I said before, like, feel like that's vaguely crimey, and he must have been intending to commit some other crime, even though we don't know what it is? Would Bragg have to say generally tax crime and election crime, even though if they don't specify it? On the other hand, I can see the point in if it is an enhancement, he shouldn't have to prove every element of the underlying crime too. Otherwise, he would just charge that crime. So what's the in between,
Yeah, I mean, there's certainly an open question as to what you'd have to prove. And by the way, enhancements of this type occur in other jurisdictions as well. And there are federal ones where having a pre-existing felony, for example, might bump up your maximum sentence. Although federally, the courts have determined that the juries actually have to find those facts that bump up the sentence, themselves rather than a judge, because they enhance the punishment. So I don't know where that would come out. I mean, I guess what concerns me, Asha, is like in the example of the burglary, all of the things you could imagine someone doing with like your burglary tools and, knife and rope and whatever are all very, serious crimes. There's no
illegal. Yeah.
But like there's very possible that like the average person in the jury has no idea what election law is, and like would have no idea. They may imagine that something that's not a crime is a crime. I mean, they just without instruction, they're really going to not have a good sense of what that is. So I don't know. I mean, I think prosecutors here left their options open, so to speak. But I do think an indictment's purpose is actually to do the opposite. It's to let not only the defendant, but the public know, here's what the charges are. Here's what we think this person did. And if you have the case, lay it out. And I guess my view on it hasn't changed, but I think it's worth, I think it's worth having that discussion, and you kind of, hopefully everybody listening to this kind of understands the nuance here. And I think it's fair to say, there's a lot about Manhattan criminal practice that everyone's learning. I mean, in most cases, one thing I learned from talking to practitioners in that jurisdiction is, in most cases, they charge other crimes in addition to this falsification of business records. So it's obvious what the other crime is. It's like rarely an issue.
That's right. They're charging the underlying crime, and so it's obvious to a jury what crime may have been intended to be concealed or committed through the falsification of documents. And I have to say, as I've thought about it more, I don't know if I'm sad panda in this episode, I'm starting to get more skeptical about just the connection between the falsification of business records and the concealing of the not disclosing for campaign finance reasons. Mm-hmm. I feel like temporally it's a little bit farther in time, and I don't know. Like, I just feel like if the idea was to just reimburse Cohen without saying what it was for, I mean, he could have Venmoed $130,000 like Matt Gaetz did and called it, for salad.
Yeah, I have to say, I really have. I've often agreed, or long agreed with you and your perspective, Asha, where you said that you thought a tax crime was that
to me is the most obvious. Like, yeah. In other words, if you were to go to a jury and say, look, this guy paid this money, Trump had to pay him back. He didn't pay him back with a check, which he could have done. This guy's a rich guy. And, he could have just said it was a check for whatever. He could have just given him a bonus. But no, they went through this very elaborate repayment scheme that was specifically categorizing this as an expense that would benefit the Trump organization in when it came to paying taxes. That's what I would say. To me, that's very straightforward.
So here's the thing. I agree with you, but I guess I have two questions about that. First of all, it's not clear from the indictment and the statement of facts what the tax crime is. I mean, But
this is the beauty. Apparently, they don't need to say.
Yeah,
I'm just saying, like, if I had this latitude to, like, let's not, where I didn't even have to tell the jury, my argument would be this could have easily just been a repayment. They didn't. They designed this with all these weird shenanigans, and they had to inflate the thing and, put this in sham invoices and record it here and do, like, why? And we know, like, they would only go, like, why else would they go through this elaborate scheme and through the organization unless it would benefit the company in some tax way? We know they were thinking about taxes because they inflated Michael Cohen's income knowing that he would have to pay taxes.
Well, that's interesting.
I rest my case.
Well, here's what I think about that. I do think the tax angles is the strongest. I also think, at least based on somebody I spoke to, that they're not 100% sure of their tax theory at the Manhattan DA. But I wonder whether they think there's some issue there that you and I don't see. Because I will say, Asha, if I thought I had a solid tax theory, I wouldn't have included the election law stuff if I was in their shoes. It's really it's confusing. It's not intuitive to think of this as a campaign contribution. It adds a lot of complexity to something and potential like appellate issues that you really don't need. So I'm really not sure why you do that if you could just have a tax case. It's very straightforward.
Well, it adds to the factual background, right? Like, you have to establish that this was a repayment for something that was being done on the sly. But I think that gets to, like, there's just not a million, but there's a lot of different ways that he could have been repaid.
Right, but why do you need to say that it was done in to conceal an election law offense, right? I mean,
I wouldn't make that argument.
That's my point. I would have just said taxes. Why is Bragg up there in a press conference talking about election law? So that's why I'm wondering, do they see some problem with the tax case that you and I don't see? Because if I'm Manhattan DA, knowing what you and I know, which is less than what they know, I would be inclined to just make your argument and not even bring up this election law stuff.
Oh, and I have one more tidbit to add.
Okay.
Legal gossip. Apparently, so one of the underlying election law crimes that Bragg specified in his press conference was conspiracy to promote a candidate in an election using unlawful means. This is New York election law 17-152. Look it up.
He said it word for word, or something very close to it in the press conference. So if you're wondering where Asha got that from,
yeah, he said he used that, and everybody went and looked it up. I thought people were like, well, why didn't he charge that conspiracy? And it seemed like the answer was because the statute of limitations had passed, because the statute of limitations is like 2 years. But I understand from a former Manhattan DA that statute of limitations could have told for the same reason that the statute of limitations on everything else has told, that's allowed him to told, meaning pause the clock, that has allowed him to bring the falsification charges. And he could have charged the conspiracy. And this former DA thought he may have chosen not to because the conspiracy is also a misdemeanor. And I think maybe the idea was only to have felonies to avoid all of the optics of having even a misdemeanor charge. But I think if you charge the conspiracy, it would make a lot more sense.
Yeah, I have to say, too, I mean, it's very problematic to have to make reference to a conspiracy that is not charged, because conspiracies, unlike something, let's say, Asha was talking about burglary before. Okay. Burglary occurs at a specific time and date. When you enter the house and you do certain things, that was when the burglary occurred, on that time and date. Conspiracies are these amorphous things that have to be specified by prosecutors. Who was involved? When did it start? At least when did it start? At least did it end by some day? What was the object of the conspiracy? This agreement, unstated agreement between these people, and who was involved? At least these people were involved. If you don't do that, you actually can have a problem, sort of a due process problem. Yeah, it's a huge.
I mean, how do you bring in all of that evidence about what Pecker and Cohen and Trump were up to like a million years ago? Going back to the burglary analogy, you can point to anything this burglar had on him when he trespassed. But you can't be like, he had a knife in his car 5 months ago, and that's not going to be allowed. A judge would be like, well, that's not relevant, and how is that related? I suppose, unless that was, you charged some other crime where that became connected.
Yeah, I have to say, Asha, if I was a judge looking at a case and a prosecutor tells me, well, we're actually believe that the defendant intended to commit this, engage in this other conspiracy, and by conspiracy to do what, with whom, when? I mean, I'd want some details, and why is this not in writing? Why are we not on notice, and why isn't the jury on notice if you're asking them to consider this a conspiracy? Usually conspiracies are defined, and it's usually a problem if it's not clear in a charging document, the contours of that. And I get that this is just a quote other crime, but I don't know. It just seems very problematic to me. Not the way that in this type of case I would do it. And now I will just say, I'll throw a couple things out there to be a devil's advocate to myself. One thing that I have heard, I hear from people, Twitter followers and so on, is, well, if you're going to prosecute Trump, why not just pull out all the stops and do whatever you got, take any advantage you can, get any edge you can. And then secondly, I hear from people like, hey, maybe if your case isn't perfect or there's issues with your case, so what? You have to hold the president to a higher bar. I think there's something to that, whether the president should be a higher or lower bar. But in terms of cutting corners, I really just believe that prosecutors should be held to a standard where they don't. And prosecutors should actually be trying to do justice and not trying to sort of get every edge, even if it's unfair, to win a point. I just don't think that's how prosecutors should be.
So to be fair to the Manhattan DA's office, my understanding is they're not really cutting corners, because this is how they charge these crimes all the time. So I mean, I think it's important to say that they're not, streamlining this or making this more obscure than they have in other cases. It sounds like when they charge these, they never specify the underlying crime, though, as you noted, they often charge another crime, which makes the connection perhaps more obvious. However, I think your point is, in this case, they actually needed to hold themselves to more than just, they needed to look at what kind of notice, given that this is such a historical prosecution, what kind of notice are they giving? And for the American public to understand what this is about as much as a future jury, and to give notice to the defendant.
Yeah, and I guess, and I'll even go further than that. Most of the time, the vast majority of the time, as I understand it, this is a non-issue in their cases because it's obvious what the other crime is. But in cases where it's not obvious what the quote other crime is, unless it's a case where you've kind of worked out a plea in advance, or that's why my sense of this is a sort of crime that's often charged as like a backstop or a throw-in. Another case in indictments where there's other crimes. But if there's a serious contested case, whether it's John Doe or Donald John Trump, you should let them know if there's no way of them to really know what the crime is. You should make it clear to them, and you shouldn't be kind of quote keeping your options open and figuring it out close to trial, and making it a mystery to the jury as to what the crime is. Even if a court will allow it, I just don't think it's right.
And to your point on that, the not necessarily a throwaway, but like adding it on when there's a bunch of other stuff. The charges against the Trump Organization and Weisselberg, there were, I think, 2 or 3 counts of falsifying business documents with the intent to commit or conceal another crime. The underlying crime wasn't mentioned, but there were a slew of other counts too, of a bunch of other crimes. And in the facts, it becomes clear where the falsification fits into all of the double books and the overvaluation and all this other stuff that they were doing. Like, it's not a mystery.
That is my understanding, is that's a more typical prosecution. And when I say add-on, I'm not saying it's not a serious crime. There's a lot, give comparable federal crimes, lying to a federal agent or structuring or things like that often are put in addition to other crimes, but they're occasionally are standalone crimes. But they're rarely charged alone. My sense is that this is one of those that usually is charged in conjunction with other crimes. And that's what I meant by that. So before we go, I guess we could talk briefly about something we didn't talk about. Because you had wanted to bring up, you wanted to do another subject, and we ended up not doing it this week.
Oh, yeah. So Renato and I always go back and forth over the weekend on what topics we want to do. Sometimes it's obvious. Sometimes it's not always. Like this week, there were a bunch of things that happened. And one that seemed like what we would want to talk about is the ProPublica reporting about Clarence Thomas and his $500,000 luxury vacations by some rando billionaire in Texas.
Yeah, and one thing I said in response to that, and we're talking about this because we try to be very transparent with all of you, is I'm like, hey, I'm a partner at a big law firm, and we have cases in front of Justice Thomas. I just don't think I can comment on that right now. And so, one thing you'll notice is that sometimes I don't comment on certain stories or about certain judges and stuff, and I do that because I have ethical responsibilities. Actually, even if a client isn't my own, if they're one of my partner's clients, they're technically mine because I'm a partner at the same firm. And so I have to be careful about that. I don't view it as sort of being unfair or pulling my punches. I just think, unfortunately, as a lawyer, there's certain things I can't talk about.
Yeah. I mean, I think that's true anywhere, right? Like, you have certain things that aren't necessarily prohibited, but end up being very touchy things. I remember when the admissions scandal broke. And,
yeah,
I had been the dean of admissions at Yale Law School for 12 years, and I was a former FBI agent. And I was like, well, admissions, FBI, 2 great tastes to go great together. Like, this is like totally in my wheelhouse. But, Yale was implicated in that. And so it was a little dicey because I still work there. And actually, I ended up giving an interview to the Yale Daily News about something completely different. I had written an op-ed on a kind of tangential issue about how this will give the wrong impression to future applicants and dissuade them from applying or something. And Yale Daily News called, and in that interview, like, I very mildly, had just, suggestions for improvement about Yale admissions, and I got in trouble. So.
Yeah. I mean, it's just, I don't think any of us want to get in trouble, but it's an interesting thing. I mean, we're talking about it now because it's kind of, it gives you a sense behind the curtain. I mean, a lot of people who comment, on legal stuff, aren't doing what I'm doing. They aren't practicing law. So it's not as big of an issue. But I think everybody, as Asha said, everyone's got situations like this. So it's interesting. But we have plenty to talk about anyway. It was a pretty full episode.
Plenty to talk about, though I am sad because I wanted to talk about who, by the way, I mean, he's an alum of our law school.
True. I did. I will say this. I'll recount a story. I did meet Justice Thomas when I was at Yale Law School, and during the summer I had worked as an intern in the Senate for a senator, and I saw him in the lunchroom, and I'm like, oh, I'm a law student, and he's like, oh, where do you go to law school? I said Yale Law School, and he's like, I'm very sorry to hear that, and then he walked away. True story. He was not a big fan, at least at that time.
No, he was not a big fan. My understanding is that he had put a 15-cent discount sticker on his Yale Law diploma for a long time. But the law school courted him back. There's now a portrait of him at the law school, I think in the alumni reading room.
There you go. There's a lot of portraits of distinguished jurists at the Yale Law School. And
there
others,
are.
Yes. Some less distinguished.
And Bill Clinton.
And Bill Clinton.
MSW Media.